Welcome to The Good Bot, a podcast focusing on the intersection of artificial intelligence, healthcare, and law. I'm Brett Mason, your host. As a partner and trial lawyer here at Troutman Pepper Locke, my primary focus is on litigating and trying cases for life sciences and healthcare companies. However, as a self-proclaimed tech enthusiast, I am also deeply fascinated by the role of technology in advancing the healthcare industry. Our mission with this podcast is to equip you with a comprehensive understanding of artificial intelligence technology, its current and potential future applications in healthcare, and the legal implications of integrating this technology into the healthcare sector. I am excited to be joined by three of my fellow Troutman Pepper Locke partners today. The first is Rusty Close. Rusty is an experienced technology attorney, which is perfect for this podcast, and he routinely advises and counsels companies on complex transactional and intellectual property matters. So, Rusty, thanks for joining us.
Glad to be here.
Also joining us is Austin Padgett. Austin Padgett is also a partner in our Atlanta office of Troutman Pepper Locke. He is a copyright, trademark, and advertising attorney in our intellectual property group. So that is going to be a lot of the focus of what we'll talk about with Austin here today. Thanks for joining us, Austin.
Yeah, the pleasure is mine.
And finally, we are happy to welcome back to the podcast Brent Horde. Brent is also a partner at Troutman Pepper Locke, and he is in our privacy and cybersecurity and data privacy practice group. And we're excited to have him talk about the interaction of IP and privacy with us today. Thanks for joining us again, Brent.
Great to be back.
So let's just get started with the basics. Our goal today is to talk about intellectual property and privacy considerations, specifically in contracting and negotiations around these issues. So, Austin, why don't you start us off and explain what are some of the main concerns when it comes to artificial intelligence and intellectual property negotiations, contracts in a healthcare type setting?
Yeah, I put the high-level concerns in two categories. First, with pre-existing content that we own or we have a license to, what can the other party do with it when it comes to using or building AI-based tools? That's an issue of control over your own assets. So that's the stuff we already own, the old stuff, if you will. The second category relates to new stuff. In the creation of new content, is an AI solution being used? And if so, we've raised a question then about the ownership of that new content.
And how does AI complicate the questions that you're asking about ownership?
Yeah, let's take a case where a healthcare organization hires a marketing agency, and that marketing agency is going to use some AI tools. If the AI creates content, and we're still working out these issues in a set of cases that we're watching and or participating in, but the Copyright Office itself has set out a white paper that tells us that such content that the AI creates is not copyrightable. That means the organization and really no one can own it in the traditional sense, which is a significant concern if you haven't anticipated that in your agreement or your business plans.
So you just mentioned that white paper by the Copyright Office. Can you tell us more about that and how you're taking that into consideration when you're advising your clients?
Over the past year, the Copyright Office has released this multi-part report on AI and copyrightability particularly. It doesn't carry the force of law per se, but it outlines the office's position on the issue. And the report emphasizes this constitutional requirement for human creation for copyright protection. It references cases like the PETA monkey selfie case, which is a relatively famous copyright case, to illustrate these principles. And so if you're looking for that discussion in the white paper, you want to look at what's labeled as part 2, labeled copyrightability.
So for our listeners, what is the PETA monkey selfie case? Because I don't think most of our folks here will have heard of that.
Okay, this is a case where an artist went out into the jungle and put up a camera. And it so happened that, we'll call it a monkey, there's a specific species that's referenced, I don't have it off the top of my head, comes and takes a picture of itself, as in a selfie. And then PETA used this on behalf of the monkey to present a copyright action over the use of that photo and the distribution of it. And PETA would have its own purposes in that, because this is the question of personhood. Does the monkey get a copyright in that photo the same as a person would have? And the court ruled that no, a monkey is not a human, and therefore there can be no copyright. And so PETA's plans were thwarted for that issue on that day. But that's the nature of the case. And that principle is the important one: human involvement. The Constitution is where the copyright clause is embedded with the patent clause as well. And ultimately, everything goes back to that. And the Copyright Office is deriving and trying to explain that, in its view, copyright requires human creation.
So in this instance, AI created content is the same thing as a monkey creating content.
For our purposes, for sure. Yeah.
Okay. So that kind of covers the high level issue of the second category or the second bucket you mentioned. But let's go back to the first category, which would be the pre-existing materials that a company already has. What are the concerns there, and what advice are you giving to clients when they're contracting around that?
What we have is a series of ongoing cases right now that relate to how existing material interacts with AI. So if you have a batch of content, can I take it and build my own AI model with it? If I'm providing services to you, can I plug your content into a third-party AI tool, let's say, to help me build my analysis or whatever I'm going to do for you as a vendor or something like that? The courts are considering whether these types of uses are fair uses that are not subject to copyright prohibitions. Well, if that's the case, that's tough for the content owner that didn't anticipate that kind of use and agreement before handing over the company's most important work product. So if you own content, you typically want to control its use and know what's happening with it. So in agreement work, I don't want the default rules of fair use or any of the other default rules of copyright ownership or copyrightability to apply. So I think about, where can I set out specifically the parties' respective obligations? One issue that we've had, typically in an agreement, you'll see that we've always assumed that there was human involvement in creation in these types of works. And so we've always assumed copyrightability as well. And so you'll have reps and warranties about, okay, well, you're going to own this, or you already own this and you're giving it to us, those sorts of things. Now what we see are additional representations about the actual ownability of the stuff that's being made or that's being licensed.
What I really appreciate about what you just said there is not just relying on kind of the default that's been used prior and what we have expected along the way. And I think, Rusty, that really ties us into what we've talked about in preparing for today. How does that affect your negotiations and your contracts? We don't want to just use the default, right? We want to actually specifically lay out what we intend to do with these various issues.
Yeah, I mean, one of the big things Austin and I always talk about is don't rely on the defaults that intellectual property law sort of provides for us, because it just didn't anticipate all of the things we deal with in this day and age. It's just not set up that way. And so what we're always counseling people on is, I always use this term, be really intentional in your use of these tools. So that can be the way you integrate them into your products, the way that you use them to help accelerate the development of your products, all of those kinds of things. And then, it's like, well, what do you mean when you say be intentional? Be intentional. And I think it's understanding the implications of their use and how incorporating them into your products might have an implication. And like Austin said, some of this stuff is unsettled. So are you doing something that on the one hand is making you more efficient, making your development process faster, whatever the case may be, but on the other hand is going to potentially cause problems for you down the road?
One of the things we talked about, again, being intentional in the contracting, is how important it is to set clear terms in the contract so that both parties understand what they mean and to hopefully avoid future disputes. So can you tell us a little bit about that and some of the terms that you're having to set around artificial intelligence?
If we envision a scenario where you have a product, you've got a software tool, a SaaS platform, whatever it might be, and let's just say that it does incorporate some aspects of AI. Maybe it's in the way that it analyzes information that your customers put into the system, whatever it is. It goes back to what Austin was saying, but if you're the customer in that situation, you want assurances that the software provider is using those tools in the right way, just to kind of put it at a high level. And so what you'll see is any use of AI tools, just generally speaking, is going to conform with AI law. And then we'll define AI law as best we can, referring to EU Artificial Intelligence Act or different types of regulations and things of that nature. Again, some of it's going to be unknown, but we want to put the onus on the people who are making these tools available in this situation, that they're using them the right way, that they're not going to take our information that we're putting into the system that's important to us and let it be distributed, far and wide or in a way that we can never get back.
Yeah, I think defining AI law might be one of the most difficult parts of that, because as we've talked about a lot in this podcast, it just keeps changing. And we know that the law is always pretty slow to catch up to technology. So good luck to you on doing that.
Right.
Do you recommend defining generative AI in these contracts? And how do you define that?
It's going to depend on the scenario, but where this might come up is, let's say that you've got a software tool and someone's doing diligence on your company because they want to make an investment or an acquisition. We see this come up in the diligence ask, or they're asking the target to rep and warrant whether they have or haven't used generative AI in the development of their product. And yes, you'll see a definition. It can mean a lot of things, but it's a specific type of AI that's focused on creating models or generating new and original content or whatever that might be. But you will definitely see that, especially it's getting more common in these, like I said, in these asks and these diligence requests. And it goes back to that same question of, are you being intentional in the way that you've used these tools? And are you understanding the implication? Like Austin said, they're trying to settle, okay, well, imagine a scenario where you're using AI to create aspects of your code base, but the Copyright Office is telling us that, well, that may not be copyrightable. And so then when you're repping and warranting to a potential investor or acquirer, yeah, we own everything that's in our code base. Do you actually own it? Do you truly understand whether or not you own all of those aspects of your code if you were using generative AI to help create some of it?
Anything else that you would recommend for companies when they're being intentional around these issues?
I hate to keep harping on that word, but it really goes back to just being intentional and having processes in place, educating the people in your organization or your developers or the external developers that you're working with, understanding how those folks are going about creating your platform and all of the things that they've done and that have gone into it. Because I think things can happen quickly without your truly understanding how things came about if you're not keeping a close enough eye on it.
And I think one of the things you mentioned, Rusty, when we were preparing for today that I thought was interesting is that you can't just go about business as usual with these types of issues. And you can't just try to shoehorn dealing with these issues into current IP law or current copyright law. And perhaps part of your advice that you're giving to your clients is to make sure that all of their employees or folks who are engaged in this area are not doing that they're not just going about business as usual, assuming everything is going to run the same way. Is that fair?
It's definitely fair. I mean, I think there's a real appetite for using these tools because they seemingly can make life much easier. And I think we all know that if we can take a shortcut, we might want to take that shortcut. But it's really important to understand, to have those policies in place, whether it is don't use them, right? We just don't know enough about them at this point, or use them, but you have to check your own work. You have to create your own work based on what you get out of it, whatever that might be. But it's not just turn people loose and say, hey, use it, whatever happens, happens. It's definitely not that.
Yeah. And I think we've seen a change in companies. Maybe at the very beginning, they were saying don't use it. And now they've realized that that's not really tenable and they have to. So they're moving towards, again, like you're saying, being intentional around use.
Hopefully.
And this connects a lot with Brent, things that we've talked about in the privacy space. So give us a perspective. How does privacy tie into this? Again, in these negotiations and these contracts, we're worrying about the intellectual property, worrying about the copyright issues. Now let's layer on privacy to that. How does that work? And what are you seeing?
Yeah, I think privacy in a way is running in parallel with IP, and it has similar concepts. We're looking at the two different buckets. There's kind of the input into the AI on one side, and then also the output and what's coming out, what are we doing, and what's the use case? All of this involving personal information in a healthcare setting, potentially regulated personal information. And I think that, to Rusty's point, and being intentional also applies on the privacy side of the house. And that's really around the data and understanding what data is going into the model and how you're using it, and then what type of personal information related decision making potentially is being run through the AI, and where is that data going when you're doing the processing.
So what are some areas of focus for privacy when you're analyzing AI issues in a potential transaction?
Breaking it into those two buckets, the first thing we're really looking at is understanding data rights. So if we're training an AI model and you get past the gate that we're using some kind of personal information, so we have privacy in play, is there a right to use that information to train the model? So that's looking at a privacy policy, potentially contracts with customers if it's customer data. If it's HIPAA, is it de-identified or is it PHI? There are potentially more restrictions in play there. And also looking at other data sources. There are a lot of data brokers or other resources that will provide big pools of information that you can use for training purposes. And if that is the case, you really want to look closely at the rights and make sure that you're not training an AI model on data that you shouldn't be using to train that AI model. It can completely foul everything up and end up with a model that you can't use, or you might even have to destroy. So that's kind of on the front end. I think in terms of output and understanding the third party that's processing it, is this an in-house on-prem solution that you're using and only you're using, or do you have a third-party tool? And if you have a third party involved, there's data sharing. And so in this context, it's personal information. I usually would say at least a data protection agreement or something to understand what's going on with that data. And if it's PHI especially, you definitely need to have a business associate agreement in place. And when you have those third parties, to Rusty's point, it's out in the world potentially. So you really need to be cognizant of any type of identifiable information and where it's going. The final piece to think about is a lot of the emerging laws outside of HIPAA. There are various state laws that could come into play, like Washington's My Health, My Data Act. Virginia has a new law around reproductive health information, which really requires consent for any kind of data uses, captures businesses that are not traditional healthcare that might sell products that are captured, or even provide services to companies that sell products that are covered. New York has a forthcoming health information privacy law, which also has consent requirements. So it's really understanding, I think, if I were to break it down, understand your data flows and what you want to do with that data. If you can figure those pieces out, you can put in your organizational controls and things that you would need to make sure that you're handling your approach to AI properly. And if somebody's coming in to look, for a transaction, or you're entering into contracts with customers, et cetera, you have everything buttoned up.
Well, thanks for that insight, Brent. I think that's really helpful to layer in with what we've heard from Rusty and Austin. So as we wrap up, just for anyone who's joined us, what final advice would you give to businesses navigating these issues?
I think it's just don't take it lightly. In some cases, it seems too good to be true. It seems too helpful to be true. It seems like we can cut down on months and months of work in a really short time. That might be true, but again, you have to understand the potential implications.
Well, thanks, Rusty, Austin, and Brent for joining us. I appreciate your insights on things people need to be thinking about in IP, copyright, and privacy when they're doing their transactions or contracting around AI. So thanks again to our listeners. Please don't hesitate to reach out to me at brett.mason@troutman.com with questions, comments, or any topic suggestions. You can also subscribe and listen to other Troutman Pepper Locke podcasts, including an intellectual property focused podcast starring Rusty and Austin, wherever you listen to podcasts, including on Apple, Google, and Spotify.
Copyright Troutman Pepper Locke, LLP. These recorded materials are designed for educational purposes only. This podcast is not legal advice and does not create an attorney-client relationship. The views and opinions expressed in this podcast are solely those of the individual participants. Troutman does not make any representations or warranties, expressed or implied, regarding the contents of this podcast. Information on previous case results does not guarantee a similar future result. Users of this podcast may save and use the podcast only for personal or other non-commercial educational purposes. No other use, including without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission of Troutman Pepper Locke. If you have any questions, please contact us at troutman.com.